Mr. Savage?
Lorinda Drake is innocent. And for that reason, we ask you to return verdicts of not guilty to first-degree kidnapping, not guilty to conspiracy to commit first-degree kidnapping, and not guilty to luring children. The state has overreached in this case. This is a case of overkill. First, however, I want to talk to you about some of the irrelevant evidence that was designed to humiliate my client in this courtroom. You remember at the beginning of this trial, the court made the comment that just because one side has more of a quantity of witnesses, that doesn't mean that they've proven the case, and a side with 3 witnesses might have a more powerful case than somebody with 10, or somebody with no witnesses could have a better case, right? And in this case, the state put on several police officers. All of those police officers knew nothing about Lorinda Drake's intent to inform, return, and protect this child, because they came in after the fact. All of these police officers knew nothing about what happened to Rashad Days between 9 o'clock and 9:20 a.m. And yet they were put on the stand to elicit that my client urinated on herself. Were we going to hear from an expert that was going to say that pissing on yourself is in some way indicative of kidnapping behavior, or that pissing on yourself is some way indicative of guilt? We have to remember that in this case, things turned around at 10:43 a.m. when Kelly Bukhari started accusing Lorinda. And of course she got defensive. Of course she was concerned. Up until 10:43, nobody had accused her. So of course she gets defensive, and I don't think it's rocket science to know that when people are stressed and excited and think they're getting arrested for a major crime that they did not commit, that urinating may just happen. So I have to ask you, why were Officer Gervasi, Officer Jackson, and Officer Robbins 3 times called to that witness stand to elicit that point? Why was it necessary? The only purpose it had was to humiliate Lorinda Drake in this courtroom. Because the acts that you, ladies and gentlemen, are concerned with are what happened prior and what happened up here, what Lorinda was intending. So I ask you to disregard that type of evidence in this case. We know from the state's charging document in this case, and it is instruction number 3, we know beyond any doubt that first-degree kidnapping is designed for the cold-blooded, for the evil, for the bad criminal actor. And we know that from how this case is pled, and I ask you to review instruction number 3, which tells the truth about first-degree kidnapping. Intend to hold a minor to unlawful service. I'm going to grab a minor, and I'm going to hold that minor to do some type of unlawful service. The next thing it says in instruction number 3, the intent to do an unlawful act with a minor. Chester the molester. Every parent's worst nightmare. You heard the officer up there, this is an A felony. That came through the witness stand. This is serious, serious business. First-degree kidnapping. And this tells us that this law is designed for the cold-blooded and the evil criminal actors in our society. And then this is what I expect the state is going to argue when they get up after me, and what they previously argued in this case. An intent to hide Rashad from his parents, to keep in prison or confine, to detain him in a way with the intent to keep in prison or confine him from his parents. Is that what happened here? Did she have the specific intent to do that over this 90 to 100 minute period? If you take somebody else's kid across state lines and you never tell the parent and you never have an intent to tell the parent, that would be an example of first-degree A felony kidnapping. The word imprison that appears throughout instruction number 3. when we review what first-degree kidnapping is. In prison. Did Lorinda imprison this child? The child said he was treated nice. Within 90 to 100 minutes, he's returned to the care of school authorities. It's meant for predators. Read instruction number 3. Read the way that first-degree kidnapping is pled in the indictment in this case. And it's pled as it goes to Lorinda Drake. They're going to get up and argue the hide from parents, but the rest of it is in there, which tells us what first-degree kidnapping really is. It's for cold-hearted actors. Specific intent. Lorinda did not have criminal intent in this case. All of the charges involve specific intent crimes, which means that the state must prove beyond a reasonable doubt that Lorinda had the specific intent required by each and every one of the charges. Okay. Luring a child, they have to prove beyond a reasonable doubt that she not only did not have the consent of the parent, but that she did what she did to avoid the consent of the parent. And the evidence doesn't tell us that. They have to prove for conspiracy to commit kidnapping that she specifically intended to kidnap. So by definition, if they can't prove the specific intent for first-degree kidnap, that she intended to hide this kid from his parents, then by definition, they can't prove conspiracy either, because to prove conspiracy, they have to prove the specific intent to kidnap. So with kidnapping, so also goes conspiracy to commit kidnapping. And you have in instruction number 13, if the state fails to prove the specific intent required for these specific intent charges, Lorinda Drake is entitled to verdicts of not guilty on those 3 counts, because those 3 counts, as the top of the instruction tells you, are all specific intent charges. We actually have the intent to keep, imprison, or confine. We have to detain the child with the intent to keep, imprison, or confine for first-degree kidnapping, the intent to commit first-degree kidnapping for conspiracy to commit kidnapping, and for luring a child, you have to be thinking, I've got to keep him from his mom. I've got to keep him from, and that's not what happened here. She doesn't have the criminal intent. She's not guilty. Let's talk about Lorinda's decision-making. We get it. The defense gets it, that the decision-making is not what most others would have done in this case. And the state wants you to play on this page, quite frankly. They want you to say, because it's not what I would have done, therefore the right decision is guilty. That's not the law, and there's nothing in these instructions that tell you that. Keep your eye on the ball, look at the instructions, and you'll come to the right verdict in this case. Back to school. Sure, that would have been the easiest way to handle this situation, take the child back to school. But you heard Lorinda. She had a gut feeling that the school wasn't safe. So she's not trying to hide him, she's trying to protect him. He got off of school grounds. At some point she learns, and she returns him to school authorities within 90 to 100 minutes. And mom doesn't find out of the situation until close to 10:30, and the child, Rashad, is returned at 10:52. Okay, so I understand, and you heard Lorinda say that she understood the mother's feelings, and certainly those are reasonable and understandable. But we need to put it in perspective when we compare it to the other types of incidents that we're talking about here. The intent to have a child to commit an unlawful act on a child, the intent to hold a minor to unlawful service that you see in Instruction 3. And we need to put it in perspective and realize that this isn't the intent that we're talking about. The backpack. The state's going to make a big deal, has made a big deal about the backpack. They'll continue to make a big deal about the backpack. You know what? She didn't think to look in the backpack. In hindsight, she should have looked at the backpack, in the backpack. It's easy afterwards to show the backpack and it had the address in it, but it certainly doesn't prove that she's an evil actor or that she has evil intent, that she didn't think or she didn't look in the backpack. She didn't call 911 immediately. She told you in hindsight that's probably what she should have done, but again, flawed judgment, mistake, does not convert something into criminal conduct in our community, in our society. The police station, could have taken him to a police station, certainly, could have done that. And then the media, this whole thing about the media. If she wanted to return Rashad, and she had a pure heart about it, and the media happens to be called, that also doesn't convert this into a felony first-degree kidnapping case. And the fact that the media was at Joe Mackey Elementary School for 3 days following this doesn't convert this into a first-degree felony kidnapping case. Perhaps the media coverage at Joe Mackey for 3 days might convince somebody to get them the crossing guard they need, might convince somebody to get extra precautions at the school so this doesn't happen where a 6-year-old walks off school property. The media is a red herring in this case, but it's all they have, and they're going to continue on rebuttal to go there about the media coverage. The fact that Lorinda Drake did not take Rashad Days back to that school does not make her a first-degree felony kidnapper. The fact that she did not look in the backpack does not make her a first-degree felony kidnapper. The fact that she did not immediately call 911 does not make her a felony first-degree kidnapper. And the fact that the media showed up and the media covered the story because, quite frankly, it was a newsworthy story of how a 6-year-old kid was able to walk off of school grounds and wasn't protected, also does not make Lorinda into the first-degree felony kidnapper that the state has charged in this case. No criminal intent. The kidnapper, and you have it in your instructions, the kidnapper keeps, imprisons, detains, confines, is the way the instruction reads, confines, from the parents. Okay? The kidnapper who takes a child with the intent to molest that child clearly has the intent to keep, imprison, confine that child from his parents. The kidnapper who takes a child to collect a ransom clearly has the specific intent to keep, imprison, or detain or confine that child from his parents. The kidnapper who steals somebody else's child from their home and crosses state lines because they want to raise that child as their own is clearly has the intent to keep, imprison, and detain that child from his parents. And then we have Lorinda, whose only intent in this case is to inform, return, and protect Rashad Days. Some of you might consider that the execution of the return, inform, and protect is flawed. Some of you might think it is wacky. But that doesn't convert this into criminal behavior, and it certainly doesn't convert this into felony first-degree kidnapping. The intent for kidnapping is detain and imprison from the parents, and Lorinda assured that Rashad was safely returned to his parents by getting him to school district authorities on Sahara, okay, to the main school district administration building. And we know that you would think that Lorinda took Rashad, and if she had the intent to hide him from his mom, to confine him from his mom in the school, to detain him, to imprison him from his mother, she wouldn't call anybody. Now, this child's mine now. I'm taking him. That's the kidnapper. But we have a completely different version of events in this case. We have a 90 to 100-minute period where there is effort after effort after effort to let school authorities and mom, Miss Burton Days, know what is going on. From Jump Street in this case. The rescue of Rashad occurs at 9:12. Okay? You heard one witness say half a block. You heard another witness say 2 blocks. I think another witness said close to 3 blocks. He was off school property, and he was in the desert area off of school property. Rashad Days is alone, undisputed. It's undisputed that Rashad Days was unsupervised, and it is undisputed that he was off school property. And he is 6 years old, and we can all agree that that is a dangerous situation. Rashad left the front gates. Nobody saw him leave. Walked out unattended and unsupervised. Left the front area of the school unattended and unsupervised. Walked to about that street unattended and unsupervised. And that's where the events in this case really begin. As early as 9:25, Joe Mackey is getting a call from Lorinda. Intent to imprison? Intent to confine? I don't think so. Because what we have at 9:25, not hiding anything. Beth Davignon, the office manager, the office assistant at Joe Mackey. I have Rashad, is what Lorinda says. Not hiding anything, not concealing anything. I have a boy who goes to your school named Rashad. First, she says, do you have a boy missing named Rashad? Beth is able to confirm that they do, and then Lorinda, well, I've got him. Okay, completely honest. There's nothing sinister about this. Not hiding anything from authorities. Shows no evil intent that within 10 to 15 minutes of picking up this child, there's a call made to the school. The intent is to inform school authorities of the intent to return Rashad Days and to tell them that he's protected. He's not alone anymore. He's not unattended anymore. He's not unsupervised anymore. I'm getting him back to you. 9:30, just 5 minutes later, there's a call made to the higher authority of the school district. They want to tell everybody. Lorinda wants to tell everybody what's going on. I'm going to return this child. I found him. It was a dangerous situation. That's the intent here. Leaves a voicemail message at the school administration building. Informs them of the intent to return Rashad Days. And again, at 9:30, we have evidence of Lorinda Drake's intent to inform, return, and protect Rashad. We go to 10:01. We have an effort to talk to the mother of this child. Okay, Cindy Crone's call evidences that, where there's an effort to get the telephone number of the mom. It's very clear through the evidence that both Lorinda wanted Miss Burton Days' phone number, and Miss Burton Days wanted Lorinda's number, and because of school district policy, that couldn't happen. Now there may be rational policy reasons for that rule, not to exchange numbers, but your job is to analyze the intent. And if she wanted the mom's number, that shows an intent, not to hide, conceal, or imprison. It shows an intent to inform and return. Cindy Crone doesn't tell them, wait at the residence for police to arrive. Didn't say that. And she's an authority at the school board. You heard her position. She's high up. The expectation was, at that moment, that at 11 o'clock, Rashad Days would be turned over to school authorities. It was an hour later or so. 10:05, we have an effort to talk to mom again, and that's with a phone call back to Joe Mackey. Yet another call that evidences, and not an intent to keep, imprison, or confine, but an intent to inform, return, and protect. Effort to talk to Rashad's mom on the 10:01 call to the 10:05 call back to Joe Mackey. The call was made. Lorinda testified to it, and Elvia Lord confirmed that there was a call. She couldn't remember too many details about it, but the call was obviously made to inform, return, and protect. 10:43 is when things radically change in this case. Because up until 10:43, we don't have any sense of a problem. Cindy Crone certainly hasn't treated Lorinda Drake as a criminal. The school hasn't treated Lorinda Drake as a criminal, and they're under the understanding that based on the Cindy Crone phone call, that 11 o'clock, everything's going to be over with this at 11 o'clock. The kid will be back safely with the school district. Done. And what happens is Kelly Buchery gets on the line and starts accusing Lorinda in a direct, firm tone. What are you doing driving with somebody else's kid around town? And the rest of it, et cetera, et cetera, et cetera. And Lorinda freaks out. Another important thing to note, we're just 9 minutes away, about 9 minutes away from the arrival at the school district and the safe return of the child when this happens. But Lorinda is, of course, upset and defensive. Nobody said this to me before. I thought I was doing a good deed. Nobody, said that I was doing anything wrong. And she gets defensive, as anybody might be. And that's why the evidence of the urination is so offensive in this case. She's honest with Kelly Buchery. She says she's got Rashad. Of course she's defensive because she's being accused, and the tone has changed. The tone of events has definitely changed based on Kelly's demeanor. She's informed of the safe return to the school district. She says that she's somewhere on Decatur on her way, and indeed, in just a few relatively short minutes, she arrives, and Rashad is safely returned to school authorities. Even the 1043 call that was accusatory shows that Lorinda's intent is to safely return this kid to the school district. Is she concerned after this call about whether or not she's in trouble? Of course she is. She's just been accused for the first time, of criminal behavior, of doing something wrong, when she hasn't. And then at 10:45, we have the 311 call. You heard that call in this case. Make sure that you listen to it again, and again, and again if you need to. That call speaks volumes, because she does tell the officer she's concerned. She says, what happened if I found this a boy, and what's the policy, and am I going to be in trouble? Because she's freaked out after the Buchery call. It makes sense. And hanging up on Buchery, some of you might find it disrespectful, but you know what? At the time, she's upset. She's close to returning this child, and all of a sudden, she's very, very, very defensive. And I don't think that's unreasonable at all, based upon what was going on here. So listen to the 311 call and listen to Lorinda. Again, honesty. I've got the child. Okay. I'm returning the child. Again, we have an overwhelming theme throughout this time period of inform, return, and protect. Let's review the 311 call in greater detail. She informs the cops of the situation, that I've got the kid. She's concerned, so yeah, absolutely, am I going to be in trouble? That's natural. Safe return to school authorities, and again, the same theme every time. She's informing authorities now. So she's now, by this time, she's informed the police, she's informed Joe Mackey, she's informed the main school administrators of the Board of Trustees. She's informed every top authority who wants to know about the situation of what's going on. And she's done so in an honest way. And at 10:52, we have the safe return of Rashad. Ladies and gentlemen, justice is very much, you get to do justice in this case. You get to decide whether what happened during this hour and 40 minutes deserves to be in the same category as instruction number 3 tells you, with the person who intends to do something unlawful to a minor, intends to hold a minor to unlawful service, somebody who steals a child and goes across the country. You get to decide. You get to decide whether the government is overreached, and you are the group that has that power to be a check on that power in this case. And we're confident, very confident, that you see the difference between this and the other intent, the specific intents that are required for first-degree kidnapping in instruction number 3. The intent is not to keep, imprison, or confine. The intent is to inform, return, and protect. as wacky or as flawed as some of the decision-making was, it still doesn't come close to being the level of felony, a felony, first-degree kidnapping. She is not a kidnapper. Now you see on the screen a door with 12 locks. And I'm going to direct you to instruction 16 because this visual goes to instruction 16. Because it says that if just one of you does not find the required specific intent for first-degree kidnapping, one of you, you're allowed to put your foot down and shut down first-degree kidnapping, and then you just consider the lesser of false imprisonment. Okay? That's what instruction 16 says. You are instructed that if you find that the state has established that the defendant has committed first-degree kidnapping, you shall select first-degree kidnapping as your verdict. The crime of first-degree kidnapping may include false imprisonment. You shall find the defendant guilty of false imprisonment if one or more of you are not convinced beyond a reasonable doubt that the defendant is guilty of first-degree kidnapping, and all 12 of you are convinced beyond a reasonable doubt that the defendant is guilty of the crime of false imprisonment. If you have a reasonable doubt between the charged crime and a lesser included offense, you must return a verdict on the lesser included offense. So if one of you feels that there's not enough specific intent, you don't have to open up that door. And that's the power that you have individually as jurors as well. And then you would consider false imprisonment, and then you would have to decide. And the difference between false imprisonment and first-degree kidnapping is specific intent. The instruction also tells you that false imprisonment does not require specific intent, that general intent is enough. So that if you do something without the legal authority, but you have a good intent, it's not the good. You can have a good intent and still be found guilty of a general intent crime, but false imprisonment doesn't apply here either, because imprisonment. Did she imprison Rashad Dates? And did she do it falsely, or did she do it with the intent to inform, return, or protect? So she's not guilty of that also. Now I want to talk about instruction number 19. Lorinda Drake is not guilty, and the instructions tell you that in order for her to be found guilty, the state must prove all the elements. Specific intent is what we're arguing over. Let's cut to brass tacks. This is about the specific intent element of these charges. They have to prove beyond a reasonable doubt, and the instruction tells you that you must have an abiding conviction in the truth of the charge. That's what instruction 19 says, that you must have an abiding conviction in the truth of the charge. Your decision, this is one of the most important decisions you will make. Your decision must abide by you today, tomorrow, 5 years from now, 10 years from now, 15 years from now, because it will abide by Lorinda Drake for the rest of her life. Which means that if you're in a conversation 10 years from now, and they learn you were on a first-degree kidnapping case, and the person, oh, first-degree kidnapping, oh, I bet the kidnappers were trying to molest the kid. No, it wasn't like that at all. She took the kid home. She may have made some flawed decisions, but within 90 to 100 minutes, the kid was safe. There was never any evidence of molestation or doing anything bad to the kid or abusing the kid. I bet it's, they wanted ransom. I bet they took the kid to call the parents and to get ransom. No, it wasn't like that either. The child was alone, unsupervised. He was a couple blocks from the school. And again, there was some flawed decision making, but there was never any evidence of any intent to call for ransom. Oh, I know. They wanted to steal the child and take the child across country so that the parents couldn't see the child again. No, it wasn't like that again. It was during the 90 to 100 minutes that this kid, that the child was without his parents and away from the school. There was never any intent to take him away without permission. It was just returning the kid. They were intending to return the kid. I bet the kidnappers had to be apprehended at gunpoint. No, that didn't happen either. The evidence was that at 10:43 is the first time that Lorinda was first accused on the telephone, and just 9 minutes later she returned the kid safely, and she was arrested for kidnapping. Can you have an abiding truth and the abiding conviction in the truth of the charge? Is it something that will abide by you? It can't, because Lorinda Drake is not a first-degree felony kidnapper. Several things can happen, ladies and gentlemen, when a child is unattended and unsupervised in our community. You can have the perfect Good Samaritan, the Good Samaritan who makes all the right decisions. You could have the flawed or the wacky Good Samaritan who does the right thing and executes it in a flawed way. Or you can have the person who ignores the situation. September 8th, it's hot outside in Las Vegas. Even if there's a 1% chance that a child could suffer from dehydration, even if there's a 1% chance that a predator happens to be close by at that time, do we want the Lorinda Drakes of the world who may be flawed in return of the child but have the right intent? Would we prefer to have the Lorinda Drakes of the world rather than somebody who completely ignores the situation and later on the news they hear maybe that a child was killed or a child suffered dehydration? Oh, I passed that kid. I passed that kid. Oh, that's a shame. That person certainly doesn't have to sit in this chair. Ladies and gentlemen, this chair in a kidnapping case is reserved for a predator,
Objection.
for a child stealer,
Sustained.
is preserved for somebody who has criminal intent, specific criminal intent to commit first-degree kidnapping, conspiracy to commit kidnapping, and luring children. Lorinda Drake did not have any of that intent. And we want, as a society, the flawed Good Samaritan to pick up and protect children instead of the predators. Find her not guilty of these charges.
Thank you, Mr. Savage.